Hello.
Hello. Hello.
Hi.
Hello.
Sorry for late, but we were waiting for the end of other meetings in Click Meeting.
Hello,
Hello.
everyone.
Hello, Wojtek.
Hi.
Okay, so I see we're all together. No one is missing, so we can start. One moment. Okay. Please tell me, can you see my presentation?
Yes.
And now it's okay? Because I used presenter
It's
view.
okay.
It's okay.
Yes, everything is okay.
Okay. So again, everyone, good afternoon. I would like to warmly welcome you and officially open our first scientific seminar. Thank you for being all of you. My name is Katarzyna Rszewska. I am an assistant professor at Kardynal Stefan Wyszyński University in Warsaw at Department of Law and Administration. And the seminars are a part of the research project Legal Protection of Children with Disabilities within the Polish-Hungarian Research Platform organized by the Justice Institute. Today's seminar is entitled Standards of International and National Law in the Protection of Children with Disabilities. It's part one of this topic. Presentation will be given by the professors from Hungary and from Poland. So, by Professor Nora Jakab, Dr. Żuża Wopera, Dr. Marta Benius, Professor Wojciech Lis, Dr. Paweł Zając, and me. We'll discuss the issues, and you can see in the presentation. Yes, okay. Can you see our topics?
Yes, we do.
So we will discuss international legal basis for the social security of disabled children, the international legal basis of the children's right to express their view in the judicial proceeding, principles of the Convention on the Rights of the Child in terms of disabled children, constitutional guarantees of providing special healthcare to people with disabilities, legal protection of children with disabilities in international humanitarian law, and the principle of accessibility in the international law. So we have 6 speakers in the meeting, and I think we can start. Please remember your time is limited, and first to speak is Professor Nora Jakab. Please, Professor, you may begin your speech.
Thank you very much. I'm going to share my screen. Where can I do that?
One moment. It's a new platform for me, and because I need to give the access, yes, but I can do it.
Excuse me, a third button in the middle of the screen, the red one. First is camera, second is microphone,
yes.
third is
This
screen
is
sharing.
enable. Yeah. Okay, thank you.
Okay,
Enable
can you?
share.
Okay.
Okay, I can do that. I think now you can see my screen.
Sharing.
Can you see it now?
Yes.
No.
You are sharing your screen, so you should choose what you would like to share with us. So first of all, you should open your presentation and then click the button of sharing the screen.
Okay, I will. But I have already shared. That's my problem. Can you see the presentation now? Okay,
Yes.
thank you. Thank you. Have I got 15 minutes, Kasia?
Yes, yes.
Okay, 15. I'm going to be as short as I can. I would like to welcome all of you, dear colleagues. I'm Nóra Jakab, as we have already introduced ourselves, and I chose a topic which is social security in this project. Social security of disabled children. Social security is closely linked to social rights. So at the beginning of my research, I started to speak and I started to examine what kind of importance of social rights have. What is the importance to include social rights in constitutions? And after that, I went to the Convention on the Rights of the Child, and I just looked on the nature of Article 26 and what kind of relations of this Article 26 on the social security on behalf of the children in the Convention exists. So this is actually the two topics that I've been dealing with while preparing myself for this open seminar. So the first one is the social rights, and we are all lawyers, but as far as it is an open seminar, I found it very important to speak about some basic principles, what we think of the social rights. And as you can see, they are very controversial areas of human rights. It is one of the most variable and variably regulated area in the human rights. And according to the same legal literature, social rights are as important a factor in a person's becoming a citizen and as classical fundamental rights. So when we talk about the presence of the disabled child in the legal field and in the legal area, I think it's very important that that this child can enjoy his or her life when this child is given the social rights as well. It's not just the political and other rights. Is it a fundamental right when we talk about social rights? Then it's important that we consider as a fundamental right that which the state in question expresses, whether it be anywhere in the world. And if a constitution names a right, a fundamental right, then this is a fundamental right. And of course, it is important to see that the extent to which a community, a society, fulfills its duty of solidarity guided by the spirit of social justice, it says a lot about the quality and the moral state of a community and a society. And that's why it's important to look at the issue, what kind of role social rights play, for example, in the Constitution of Hungary or in the Constitution of Poland. However, it's important also to say that the absence of a constitutional enshrinement of social rights does not in itself imply the lack of constitutional commitment of the state to social programs. So what can we do? It's important that there is a great debate whether social rights should be included in the constitutions or not. It's very important to say that when a state decides, then it's rather a question of choice of values. It is a values debate, an ideological debate to which it is never possible to give a clear-cut answer, but it's very important that the choice between different alternatives is primarily a function of political decision and the social philosophies, ideologies, and the value choices that are directly towards this. These should be more a part of the constitutional process, not of the constitution. And indeed, the borderline between economic policy decisions and constitutional decisions in a state regarding the social rights depends on the constitutionalization of social rights. And that's why it's important that they should be included. And when we look at the social security, then we can see that the right to social security is considered an important component of social rights as understood in this sense I provided here. And it is also usually considered, as we all know, as a subsidiary right. For example, the right to the work. And the right to social security is thus primarily concerned with the question of how, in the event of social livelihood disruption, the social conditions essential to life can be provided to the individual. And when we look at the disabled children, then it is seen that it's important to have these children the right to the social security, but it's also very important to make their parents be in the situation that they should be given the whole enjoyment of this right. So disabled children cannot be separated really from the well-being of the parents. And social security, as we see, is a quality of human life. So disabled children, quality of life, and the parents of the disabled children are also very important regarding the quality of human life. And since there is no such guarantee in the constitutions, the reality is that the sick, the starving, and in our case, the disabled, etc., are legally guaranteed a certain existential relief. But of course, they are not guaranteed, and they cannot be guaranteed real social security. It is always upon other circumstances of the state, financial, and other ideological circumstances that will make real enjoyment of this right. And how does it look like in the Convention on the Rights of the Child? As before, I've been dealing with the CRPD quite a lot, and I just learned how to handle this this convention. It was clear to me that I have to understand the holistic approach of this Convention on the Rights of the Child. And as soon as I got to Article 26, on the right to the benefit from Social Security, it was clear to me that I have to see it in a system. And of course, the starting point was Article 4, as far as I understood. Then I went to Article 26, as you see, when we can see that the child has the right, but not to Social Security, but to the benefit from Social Security. And I will come to this just a little bit later. And of course, these kind of services have to be tailored to the necessity and to the needs of the family and of the child. And I think it has also a very close relation to Article 27. However, in the literature, we have not found that close link to Article 27, but it is obvious that the right of every child to standard of living really depends on what kind of health state, what kind of social assistance this child and these children parents get. This right to benefit from Social Security, as you see, in itself plays a key instrumental role in the realization of other convention rights. I just felt myself when I was dealing with the CRPD, and with the CRPD, I've been dealing with Article 12, with the legal capacity issues, and at that time we said that legal capacity, Article 12 is also a key instrument. Now I can see that Article 26 also a key instrument in this convention. And as you see, it guarantees financial and other support of the child provided by the state in all cases where the adults responsible for the child are not in the position to provide for the child. But it's important that the child is entitled to Social Security and to the benefit of the Social Security, even when the parents are responsible and when the parents are not in the state to be responsible for the child. And I went through other interpretations of this article as well, and it was clear that the International Labour Organization insisted on the wording to benefit from the Social Security, because that's the case that mirror the best the situation of the child, as there is a dependence on behalf of the child towards their parents and the legal guardians. Of course, there can be applications for benefits made by and on behalf of the child. It's important, as you see, the reports on the conventions, and actually the committee also asked the state parties to describe in the reports what are the benefits which are directly and through a legal representative entitled for. And it's important to see in Hungary what kind of benefits we have and how the disabled children is entitled for that. During surfing in the literature, I could find, I think, a very interesting author who is called Stephen Kidd. And Stephen Kidd is involved in the rights of children and disabled adults all over the world. And you can see what the children say, how they felt well themselves in this world. For example, in Asia, or in Latin America, Caribbean, they didn't say actually different things that children would say in Europe. And then it is also clear that what does it mean to have a right to benefit from the social security? It is really a question of a progressive achievement, just as it happened to many articles in the CRPD as well. And regarding legal capacity, when we cannot really describe how an article should be implemented, then it should be target of progressive achievement. But I think it is very highlighted here, and I think this is going to be the main focus of the research. Furthermore, that we can see that the ILO 102 minimum standards on the social security, which is the basis for this legislation as well, namely the health, care, sickness, unemployment, employment injury, family, maternity, invalidity, and survival benefits are the starting point. So we should look at on these benefits when we try to map how the situation of disabled children and the parents of disabled children find themselves, for example, in Hungary. And the cornerstones of the research, furthermore, are going to be the right to benefit from social security, as you see, what kind of social security system should be set up, what is the minimum level that is defined, for example, in Hungary, and the principle of progressive improvement, how it can be applied. And I think the starting point of our research, not just mine research, everybody's research, is the equal treatment, as there is no difference between children and disabled children. And as I have run out of the time, I have just looked on the complexity of the convention in a way that Article 26 refers to other articles, and I have just seen the link between Article 26 and, of course, Article 2, Article 3, Article 6, Article 12, Article 17. You can see all the articles. They make a sort of system which is very complex, which is very holistic, and which relates to each other. So this convention is such well made and composed as the CRPD was, I think, 15 years ago. So I think this convention was a good starting point to understand a little bit more about the international standards of social security of disabled children. So thank you very much for your kind attention. You are unmuted.
Your microphone is muted.
Sorry. Thank you very much, Professor, for your detailed presentation. And I would ask for presentation Dr. Zsuzsa Vopera.
Okay, thank you so much. I am Zsuzsa Vopera, professor of civil procedure law at the University of Miskolc, and one of my special research field is the participation of rights, the child rights in procedures, so procedural rights of the children. So I'm an old school professor, so I have any PPT, sorry. I don't like to use it. Sorry, this is my fault, I know. I never use at the university lectures and in the online. So sorry. So my dear colleagues, dear research group members, I would like to wish good afternoon all of you. And I would like to say that it's a great honor for me to share with you in the next few minutes the first results of my research. But I would like to emphasize that I am at the very beginning of my research. So I will now present the basic international and EU legal background to the curing of the child. The title and the topic of my presentation is the international and EU legal basis of the children's rights to express their view in judicial proceeding. I would like to ask you that if you don't hear me, please say, because I have some technical problems. Wojtek and Marty knows that I'm full of technical problems. So please tell me if you you don't hear me. So according to my research hypothesis, whether we look at international, including EU law, two fundamental principles should prevail regarding the procedural rights of children with disabilities: the prohibition of discrimination and the primacy of the best interest of the child. Despite all legal requirements, all reports and commentaries dealing with this issue, we must note that children with disabilities are still experiencing serious difficulties and facing barriers to the full enjoyment of the rights enshrined in the Convention of the Rights of the Child, hereinafter CRC, and in the Convention on the Rights of the Person with Disabilities, hereinafter CRPD, as Nori used this shortening. The Committee on the Rights of the Child and the Committee on the Rights of the Children with Disabilities affirm that all principles and rights enshrined in the CRC and in the CRPD are interrelated with respect to children with disabilities and are underpinned by the human rights model of disability. According to the paragraph 2 of Article 12 of the CRC, ensures the child right to express his or her own views in the proceeding affecting him. According to Article 2 of the CRC, the child must be guaranteed this right regardless of disability, so the prohibition of discrimination must apply. According to Article 23 of the CRC, the state parties recognize that a mentally or physically disabled child should enjoy a full and decent life in conditions which ensure the child's active participation. In this presentation, I will first examine how to interpret the child's rights to express his or her own view based on Article 12 of the CRC in the light of the interpretation of the relevant commentaries and implementation handbooks. According to the Article 12 of the Child Convention, said that state parties shall assure that the child who is capable of forming his or her own view, the right to express those views freely in all matters affecting the child, the views of the child being given due weight in accordance with the age and maturity of the child. The second paragraph is, for this purpose, the child shall in particular be provided the opportunity to be heard in any judicial and administrative proceeding affecting the child, either directly or through a representative or an appropriate body in a manner consistent with the procedural rules of national law. The Committee on the Rights of the Child, hereinafter the committee, monitors the implementation of the CRC and issued recommendations, implementation handbooks, and general commentaries in the last 30 years for the effective application of the CRC. In the following, I will summarize the most important statements regarding the child's expression of his or her own view in procedure affecting them. The committee has consistently emphasized that the child must be regarded as an active subject of rights, an active participant, and that a key purpose of the CRC is to emphasize that human rights extend to children. The children rights referred to in the two paragraphs of the Article 12 do not guarantee the right to self-determination, but rather concern participation in the decision-making process. the significance of the Article 12 of CRC is that it not only requires that children should be assured the right to express their view freely, but also that they should be heard and that their views be given due weight. The committee has rejected the charity mentality and the paternalistic approaches to children's issues. The parents know what is good for the child. It's important to highlight that Article 12 of the CRC provides the right to express freely the views for the child who is capable of forming his or her own views. In our research project, a detailed analysis of this definition will be really important because the fundamental question is what is meant by capable of forming his or her own views in the case of a mentally disabled child. We must emphasize that Article 12 doesn't set any lower age limit on the children's right to express view freely. Some countries reported that they had set a minimum age on the right of the child to be heard, for example, in custody proceeding, following separation or divorce of parents, but the Convention provides no support for this. According to the CRC General Comment, number 12, the right of the child to be heard, the state party shall assure the right to be heard to every child capable of forming his or her own views. This phrase should not be seen as a limitation, but rather as an obligation for states parties to assess the capacity of the child to form an autonomous opinion to the greatest extent possible. This means that states parties cannot begin with the assumption that the child is incapable of expression his or her own views. The committee emphasized that Article 12 imposes no age limit on the right of the child to express his or her views and discourages state parties from introducing age limit either in law or in practice, which would restrict the child's rights to be heard in all matters affecting her or him. Article 12, paragraph 2 specifies that opportunities to be heard have to be provided in particular in any judicial and administrative proceeding affecting the child. The committee emphasizes that this provision applies to all relevant judicial proceedings affecting the child without limitation, including, for example, separation of parents, custody, care and adoption, and placement of the child proceedings. For the child to be provided by the opportunity implies an active obligation on the state to offer the child the opportunity to be heard, although, again, it is important to emphasize that there is no requirement that the child express views. So after this brief summary of the international legal background of the right of the child to be heard, let's move on to the relevant EU legal connection points. The strengthening of the child rights approach can be observed in the Council Regulation EU 2019-1111 and jurisdiction, recognition and enforcement of decision in matrimonial matters and matters of parental responsibility and on international child abduction. This is the Brussels 2B regulation that entered into force last August, the 1st of August 2022. It is clearly visible that in the Brussels 2B regulation, a major progress has taken place compared to the Brussels 2A regulation, precisely in the area of much stronger consideration of the rights and the best interest of the children. In the Brussels 2A regulation, there was no harmonized obligation for the courts of the member states exercising jurisdiction in parental responsibility matters to provide the child with an opportunity to express his or her own views. The hearing of the child was regulated only in a child abduction cases. The proceeding in matters of parental responsibility, as well as the return proceeding, should, as a basic principle, provide the child who is subject to those proceedings and who is capable of forming his or her own views in accordance with the case law of the European Court of Justice is given a genuine and effective opportunity to express his or her views. The opportunity of the child to express his or her views freely in accordance with Article 24 of the Charter of Fundamental Rights of the European Union and in the light of the Article 12 of the CRC plays an important role in the application of the Brussels IIb regulation. Article 21 and Article 26 of the Brussels IIb regulation determine uniform standards for the hearing of the child. According to the Article 21 of Brussels IIb regulation, it is said, when exercising their jurisdiction, the courts of the member states shall, in accordance with national law and procedure, provide the child who is capable forming his or her own view with a genuine and effective opportunity to express his or her views, either directly or through a representative or an appropriate body. According to the Article 26 of the regulation, the Article 21 of the regulation shall also apply in the return proceeding under the Hague Convention. It can be seen that the Article 21 of the Brussels IIb regulation uses exactly the same wording to define the range of children capable of forming their views. Nevertheless, the Brussels IIb regulation supplement the Article 12 of the CRC with two important adjectives. The child must be given a genuine and effective opportunity to express his or her own views. Nevertheless, the regulation doesn't explain when the opportunity to hear the child is genuine and effective. The leading case of the Court of Justice of the European Union, this is the Zarraga case, doesn't give much guidance as to when the opportunity can be considered genuine and effective, but it confirms that the court must be given the opportunity to express the child's view. According to the practice guide, all appropriate legal tools must be made available for the child to express his or her view freely. The right of the child to express his or her view plays a role in the recognition and enforcement of decision, the authentic instruments and agreements. The recognition and enforcement of a decision in matters of parental responsibility may be refused if it was given without providing a child capable of forming own views with the genuine and effective opportunity to express his or her views in accordance with Article 21. So, in the light of my today's presentation, in my next lecture, I would like to analyze how the standards of Article 12 of the CRC apply to children with disabilities, taking into account the Article 2 and the Article 23 of the CRC and the Article 7, paragraph 3 of the CRPD, according to which state parties shall ensure that children with disabilities have the right to express their views freely on all matters affecting them, their views being given due weight in accordance with their age and maturity, on an equal basis with other children, and to be provided with disability and age-appropriate assistance to realize that right. Thank you for your kind attention.
Thank you very much. Thank you very much, Dora Zuza Wopera, for sharing your experience. And last speaker from Hungary is Dr. Marta Benius. Please, the floor is yours.
Yes, thank you. I will try to share my screen. If I can. All right, is it visible?
Yes.
Okay. So, good evening, everyone. Dear professors, dear organizers, dear audience, it is an honor to be part of the Polish-Hungarian Research Platform once again this year and contribute to the research on the legal protection of disabled children. My name is Marta Benius and I'm from Madel Ferenc Institute of Comparative Law. My research field is the rights of the child, which encompasses and spans many branches of law, which is always the perspective of mine, as well as the confidence of the necessity of interdisciplinary viewpoint. Nevertheless, the main angle I usually look at the rights of the child is the so-called rights-based approach stemming from international human rights law. So I hope to contribute to the project from this perspective. The title of my today's presentation is The Principles of the Convention on the Rights of the Child in Terms of Disabled Children. Let me start with a short introduction on why the rights of disabled children are an inescapably important topic. According to the data of the UNICEF from 2021, currently there are 240 million children who live with some kind of disability in the world, from which 10.8 million live in Europe and Central Asia. According to Eurostat, about 5% of EU families with children had a child or more children with disabilities. We are speaking about a condition which affects every 10th child in the world. According to the research also conducted by the UNICEF, disabled children have twice the chance to be victims of abuse, are 25% less likely to be involved in early childhood development, are 49% less likely to ever go to school, 42% more likely to be malnourished, and 1 child from 3 of disabled children is deprived from loving family environment and are living in an institution. Wide range of data is presented in surveys conducted by the UNICEF. Nevertheless, I do believe that even this narrow sample is representative if we consider the consequences of not adequate legal framework and policies in terms of disabled children. Before I go into the importance of the rights-based approach towards them and into the principles that should guide this rights-based approach, let's just very briefly look at the level of protection offered by international human rights law. This is beyond question that children with disabilities, as human beings, are entitled to all human rights, and obviously all general human rights instruments are applicable here. I will now leave the analysis of this framework and more draw the attention to the special protection. Children with disabilities have special needs from 2 perspectives. Firstly, they are children and as such are entitled to a childhood that nourishes them, prepares and empowers them for adult life.
Sorry, Marta.
Secondly,
we see only first slide.
Oh, I'm sorry. I'm going. I don't know why. Because I'm going.
And other colleagues, can you see other slides?
Or yes, just the first. Just the first.
Yes, the same. Only one. The first one.
The opening. The first. Yeah. The first slide.
I'm sorry, but I'm. Okay, I will try again.
This is why I never use slides.
Because I'm actually moving the slides. Okay, I will try again. So.
Yes, it's fine.
Is it there?
Yes.
Okay. Yeah, but so children with disability have special needs from 2 perspectives. Firstly, they are children and as such are entitled to a childhood that nourishes them, prepares and empowers them for adult life. Secondly, they have some kind of disability. Both of these needs are addressed by international human rights law, by the Convention on the Rights of the Child and by the Convention on the Rights of Persons with Disabilities. It is common in both of these documents that they were widely accepted by international community. It is especially true in terms of Convention on the Rights of the Child, where there is only 1 country that has not yet ratified the treaty. It is common that both of the instruments represent a shift between the caring, sometimes in terms of disabled person medicalized model, to so-called rights-based approach, which in practice means that both documents put an emphasis on participatory rights. The Convention on the Rights of the Child recognized special needs of children, and CRPD was an answer to a systematic breach of the rights of persons with disabilities. In terms of disabled children, the CRPD rather strengthens the applicability of children's rights and the principles that should govern law and policy making than adding all new approaches. One may, I believe, well-groundedly draw the conclusion that the currently available human rights protection sufficiently covers children with disability. The devil here hides in the application, implementation, and the practice. That is why the good understanding of standards is inevitable at this point. Who are children with disability? Article 1 of the CRC says that everyone beyond the age of 18 is a child, unless according to the applicable national law, majority is reached at an earlier stage. The CRPD defines disability and also declares disabilities more a result of a social interaction rather than the actual condition of the disabled person. It precisely says that disability is an evolving concept and that disability results from the interaction between persons with impairments and attitudinal and environmental barriers that hinders their full and effective participation in society on an equal basis with others. The approach of the World Health Organization echoes on that as well, when saying disability is not a disease, but rather a condition. I believe that the more we look at disabled children from the perspective of their childhood and not from the angle of their disability, the closer we get to their effective protection. That is also why I would like to make a strong emphasis on the applicability of the Convention on the Rights of the Child and on the principles governing this very important instrument of human rights law. Before going into the principles, there is one point that I would like to make in connection with the aim of the CRC. It is very hard to formulate just one goal, but if I must, I would say that the goal of the CRC is to give a fruitful childhood to every child that helps them maximizing their potential. There is one particular provision of the CRC, Article 23, that concerns only disabled children. Nevertheless, an interpretation that would focus only on this particular provision would cause a misunderstanding of the rights of disabled children, because even though the first sentence mentions participatory rights, it is rather close to the so-called caring model than to the rights-based approach that is represented by the Convention on the Rights of the Child. Therefore, it is necessary also giving enough attention to the confirmatory nature of the CRPD to see the whole convention and all the rights through the prisma of the principles. Traditionally, there are 4 principles of the UN Convention on the Rights of the Child that are all children shouldn't be discriminated against, as Article 2 says, should have their best interests accounted for as a primary consideration, as Article 3 says, have the right to survive and develop, as Article 6 says, and have the right to have their views heard and taken seriously, as Article 12 says. Together, these 4 principles underpin how the CRC should be interpreted and put into practice. As a +1 principle, I like to add the right to live in a loving and caring family environment, which actually, in my opinion, weaves through the other 4. Non-discrimination basically means that every child is entitled to the same right, regardless of any characteristics. It is important to stress that the CRC is the first international convention that includes disability as a ground for discrimination. Research shows that the exclusive application of non-discriminatory measures, such as including disability as a ground for discrimination, an effective system system of remedy and awareness-raising campaigns are rather counterproductive and result in an enhanced discrimination. Unless having measures that lead us to the next principle, and already discussed by Professor Vopera, the viewpoint and the real participation of the child, which is, if we narrow down, would be Article 12 of the CRC. But it is actually so much more. It is a shift from being the object of protection to being a subject of the rights and take active role in enforcing these rights. The best interest of the child is one of the most widely cited principles. In practice, the principle has to be applied as a threefold concept as a substantive right, a fundamental interpretative principle, and a rule of procedure, as the Committee on the Rights of the Child cites. The principle as a substantive right obliges states to consider the best interest of the child, take it as a primary consideration when different interests are considered, and that the right is implemented whenever a decision is affecting a child. This creates an instinct obligation for the states. A substantive right is directly applicable and can be invoked before the court. The principle as a fundamental interpretative legal principle requires that if a legal provision is open to more than one interpretation, the interpretation which most effectively serves the child's best interest should be chosen. The rights enshrined in the Convention and its optional protocols provides the framework for interpretation, also the words from the CRC Committee. Assessing and determining the best interest of the child require procedural guarantees. This requires that the possible impact of a decision has to be always evaluated. States can be held accountable as they are obliged to substantiate and prove the explicit consideration of the best interest of the child and how it has been respected in any decision concerning children. And it leads us to the last but not least principle, the principle of survival and development. The principle of survival and development can only be implemented in a holistic manner as it requires a conjunctive reading with all other rights and provisions of the CRC, such as the guiding principles and substantive rights. For the purpose of Article 6, the right to survival should be interpreted to oblige states to take all appropriate positive as well as negative measures that will contribute to the survival of a child. This means that states are obliged to not only refrain from arbitrary deprivation of life, but also to implement active measures to take preventive steps to prolong the life of the children. In this respect, the right to survival corresponds with the current and broad interpretation of the rights to life to include an obligation to create the conditions necessary to ensure a life of dignity. It is underlined by research that children with disability are more likely to experience difficulties with the right to survival and all the characteristics than children who are so-called healthy. The right to development. The holistic concept of the right to development includes the state obligation to ensure the child's physical, mental, spiritual, moral, physiological, and social development. The right to development is based on the rapid and vulnerable process of development which differentiates children from adults. Therefore, it is a unique right for children and focuses on the personal development of the child. The CRC committee highlighted that the development of the child's physiological, spiritual, social, emotional, cognitive, cultural, and economic capacity fall within the scope of Article 6 CRC. The child's development, similar to the child's best interest, has to be assessed on a case-by-case basis, combining multiple disciplines. And now I would refer to the interdisciplinary approach here, such as psychologists, psychiatry, neuroscience, social work, and education. All of these 4+1 principles should be interpreted in terms of children with disabilities, giving a special regard, firstly, to their childhood, and obviously handle and consider their disability with due weight, but rather as a changing condition and a social concept than an obstacle. It is inevitable to use a rights-based approach in order to provide the chance for a vivid childhood to disabled children where their rights are accessible. Thank you for your kind attention.
Thank you, Doctor, for your reflections on the Convention on the Rights of the Children, of the Child, sorry. And now, as the first from Polish team is Professor Wojciech Lis. Please, Professor, you can start.
Thank you very much. I am a professor at the Catholic University of Lublin. My scientific interests are quite broad, include family and medical law and security issues. I am a teacher who supports traditional teaching methods, so I don't have a presentation, just a short lecture. I have prepared an issue regarding constitutional guarantees of providing special health care to people with disabilities. When analyzing the legal situation of children with disabilities, I should start with indicating the guarantee of providing special health care to people with disabilities, which is contained in the Constitution of the Republic of Poland, because of it is the highest law in my state. The legislator guarantees everyone the right to health protection, citizens equal access to health care services financed from public funds, and special health care for children, pregnant women, the disabled, and the elderly. Health is the most valuable value for a human being, conditioning the possibility of using other values. Health protection, determined by the instinct of self-preservation, is the concern of every human being. In the context of protection, the health of people with disabilities, fundamental importance has the Article 68, Section 3 of the Constitution of the Republic of Poland. It should be emphasized that healthcare is a term with a narrower meaning than protection of health, but broader than the provision of healthcare. Healthcare is one of the elements of health protection. It includes healthcare services as well as other social care services related to health. Related to health services, for example, by the fact that they are provided by medical entities or in medical entities. Moreover, healthcare is not limited only to treatment and rehabilitation, but also includes efforts to maintain health and prevent diseases by taking diagnostic and preventive measures. A common feature of entities that should be provided with special health care is, on the one hand, that they most often have an increased need for healthcare services, and on the other hand, they are less independent than the average person. Granting a special type of rights to the indicated categories of entities is a consequence of their special life situation, increased health needs, which are associated with a higher risk of various types of body dysfunctions, including higher frequency of illness and the occurrence of certain diseases typical only for these groups, which in turn is associated with the need to use a specific type of treatment. not without significance, may also be the potentially more limited access to healthcare services of such people, resulted from limited mobility, reduced financial capabilities of limited independence. It is therefore assumed that the subjective scope of the Article 68 of the Constitution of the Republic of Poland is conditioned by humanitarian considerations and concern for ensuring the development of the nation. The need to cover these groups of patients with special health care is supplemented by other constitutional provisions, in particular Article 72, which imposes an obligation to protect children in particular, and Article 69, which introduces the obligation to help people with disabilities. The provision of Article 69 of the Constitution of the Republic of Poland specifies 3 areas within which public authorities are obliged to provide assistance to people with disabilities. It is about helping to secure the existence of these people, adapting them to work and social communication. It leaves the legislator free to choose the means to achieve the objectives listed in its content. On the other hand, this freedom poses a serious threat to realization of the Constitution guarantees. On the other hand, this freedom poses a serious threat to realization of the Constitution guarantees. Providing special health care to people with disabilities is a departure from the principle of equal access to healthcare services financed from public funds. It imposes an obligation on public authorities to provide special, that is, above standard healthcare. However, the legislator does not specify to what extent and in what form the obligation to provide specific healthcare should be guaranteed. It is also not clear what specific activities should be classified as special healthcare, so public authorities have a great deal of freedom in this regard. Nevertheless, if healthcare is to be special, it should more fully than in the case of other entities pursue the health interests of entities with special health needs. This means the need to provide healthcare on different terms than those applicable in the general healthcare system. This concerns in particular the obligation to establish and finance special counseling centers or special conditions for using general counseling centers for people with disabilities, as well as providing them with special benefits in the form of additional leaves or special allowances. Special healthcare should not only be more intensive, but also adapted to the specific needs of people with disabilities. Specificity may therefore relate to the conditions, scope, availability, or financing of healthcare services. Special healthcare boils down to ensuring better access to health services, medical devices, and pharmaceutical services, that is, immediate access to them out of turn, bypassing the waiting list. The health service for the disabled should be provided on the day of reporting to the medical entity, and if it is impossible, then the medical entity is obliged to set a different date, but not longer than 7 days from the date of reporting. A special entitlements is also the right to specialist services without the obligation to have a referral, although limited only to specialist services provided as part of hospital care. Should be noted that the legislator applies guarantees to provide special health care only to Polish citizens. Since basic healthcare financed from public funds is guaranteed only to Polish citizens, the more special form of this care related to people with disabilities cannot be guaranteed to everyone, only to people with Polish citizenship. The legal nature of the provision guaranteeing people with disabilities special health care raises doubts. The problem boils down to whether it constitutes a programmatic norm, that is a norm that requires public authorities to achieve a specific goal, but without a precise indication of the legal situation of a citizen in relation to whom this goal is to be achieved. As a programming standard, this provision is not directly applicable, but requires the adoption of a law that will implement the resulting guarantees. On the other hand, it is increasingly emphasized that this legal provision may constitute a control model for examining the compliance of provision defining the principles of providing healthcare services. In addition, it confers a subjective right, the right to special healthcare, which can be claimed on the basis of a constitutional complaint and in proceedings before common courts. In other words, on that basis, it is possible to demand special healthcare from public authorities without having to wait for a special act that would make these guarantees real. It seems that in the context of the evolution of human rights, the second concept is particularly gaining in value. It should be added that the provision of special health care to people with disabilities is compensatory. The basis for providing such care is the protection of the dignity of a person in need of assistance and social solidarity. In addition, the protection of the health of disabled people is related to ensuring their health security, which is closely related to the basic need of every human being, which is security, and the obligation of the state to ensure safe living conditions for everyone. The obligation to ensure it rests with public authorities, which are to introduce facilitations and provide support to people with disabilities in basically all spheres of life, so that limitations caused by disability do not mean total social marginalization and full social exclusion of such people. Bearing this in mind, it should be stated that constitutional guarantees oblige public authorities to undertake actions aimed at providing special health care to people with disabilities in the practice of functioning of medical entities, leaving a lot of freedom as to how to determine the details of which persons, what services, and to what extent will be provided in a way that deviates from the principle of equal access to them for all persons. Thank you very much for your patience.
Thank you very much, Professor, for interesting lecture. And now, please, Dr. Paweł Zając.
Okay, good evening, dear professors, dear colleagues. Can you see my presentation?
Yes.
Yes.
Okay, fine. My old friend always told me that if you don't have anything interesting to say, put a presentation so viewers focused on pictures, not on your words. I will use this advice today, but hoping that at least a small part of my speech will be interesting to you. My name is Paweł Zając. I'm an assistant professor at the Department of State and Law Studies at the Faculty of Law and Administration at War Studies University in Warsaw, and I conduct scientific research in the field of legal foundation of state security, including social security, theory of law, cyberspace law, and canon law. As a part of the research on the social security in the context of the state security system, which I conduct in this project, of course, in terms of the protection of children with disabilities, one of the issues requiring in deep considerations in the protection of this category of entities during armed conflicts. In connection with this, I would like to present to you today the legal aspects related to this topic. At the outset, however, so systematization needs to be done. The legal protection, which is mentioned in the title of my speech, will be limited solely to the analysis of regulations relating to the civilian people. That means persons not directly involved in the conflict. Those issues related to the direct participation of children in military operation, which are regulated by separate acts of humanitarian law, will be omitted. The second issue concerns the understanding of the concept of armed conflict. For the purpose of this speech, following the International Criminal Tribunal for the former Yugoslavia, should be considered that an armed conflict exists whenever there is a resort to armed force between states or protracted armed violence between governmental authorities and organized armed groups or between such armed groups. The concept of armed conflict is broader than the concept of the war, and it includes all manifestation of armed struggle, while war, traditionally understood, is opposite to the state of peace and means a situation of armed struggle between states. Now,
Sorry, we still see first slide.
Okay. And now?
Just the first.
The same problem was with me.
Please wait. You can see now the second.
Yes, second. It's okay.
Okay. Sorry. Now that we have outlined the issues, let's move on to the analysis of the topic problem. People with disabilities rank high among those badly affected by conflict. For one thing, conflicts degrade whatever support system are in existence. The lucky one can flee, but many are forced by their circumstances to remain in the conflict zone after others have been evacuated and are partially vulnerable as a result. People with physical, sensory, as well as intellectual and psychosocial disabilities also face barriers in escaping and surviving armed conflicts. Children with disabilities are a special group at risk of such activities. Therefore, it becomes natural to provide them with the special protection and assistance during armed conflict. This task is mainly fulfilled by the humanitarian law of armed conflicts, setting standards for guaranteeing the protection of civilians during armed conflicts. Therefore, according to the fundamental assumption, the civilian population in times of armed conflicts should benefit from general protection against the danger arising from military operations. Civilians, including children, must not be attacked, threatened, or intimidated when they are not directly involved in hostilities. Unfortunately, it wasn't always like that. World War II showed that armed conflicts line with a specific worldview or ideology do not respect basic human rights, introducing a kind of categorization of people into those who are worth living and those who can be eliminated. An example of this awful act was Operation T4, that means elimination of life not worth living, consisting in the final elimination of people with disabilities. This practice was argued by the fact that it would be beneficial for the state because it would relieve the health system and also keep the purity of German blood. It is estimated that during World War II, the Germans murdered about 200,000 people with mental and physical disabilities. At the peak of Operation T4, the Nazis killed over 70,000 psychiatric patients, including 10,000 of children. The experience of the crimes of the World War II prompt reflection on the creation of an effective system of protection of civilians, including children, during armed conflicts, which result in the adaptation of the Geneva Conventions together with additional protocols. This act set the standards of protection for civilians. Currently, the fundamental guarantee of protection under Article 75 of the first additional protocol requires human treatment without discrimination on grounds on race, color, sex, language, religion or belief, political or other opinion, national or social origin, property, birth or other status, or any other similar criteria. Each party to the conflict should respect the person, dignity, beliefs, and religious practices of all such persons. In section 2 of this article is a list, the acts that are always prohibited against children and other protected persons, like attack on the life, health, or physical or mental well-being of such person, in particular murder, torture in all its forms, physical and mental, corporal punishment and mutilations, attacks on personal dignity, especially humiliating and degrading treatment, forced prostitution, and all forms of death, hostage taking, collective punishment, treat of committing one of the acts listed above. In international documents, provisions concerning the protection of children during armed conflicts are often combined with the provisions relating to the protection of pregnant women, mothers of children under 7 years of age, and the elderly, injured, and sick. This is because the rights of children are extrability linked to the rights of mothers, and because children, women, and the elderly, and those who are out of combat are particularly vulnerable targets. This is confirmed in Article 14 of the Fourth Geneva Conventions, which provides for the possibility of creating special zones and designated sanitary places where the above mentioned groups of people would find protection against the effect of the war. An important element of the protection of children in time of war is formulated in Article 24, 4th Geneva Conventions, which say the obligation for the parties to the conflict to take all necessary measures to avoid abandoning children under 15 who have been orphaned or separated from their families as a result of the war, and to facilitate in all circumstances their maintenance. the exercise but not religious practice, and their educations. Parties to the conflict, with the participation of national and local authorities, should facilitate the functioning of institutions dealing with the care and upbringing of children. The use of the phrase facilitate suggests that it's rather a postulate addressed to the parties to the conflict, setting out the desired direction in which the conduct of children during war should go, rather than a binding rule. In Article 38, Section 5 of the Geneva Convention provides for the obligation to provide privileged treatment the same as the enjoyed by national of the country concerned to children under 15 years of age, pregnant women, and mothers of children under 7 years of age. In Article 77, Section 1, the first additional protocol recognized that children should enjoy special respect and be protected against all forms of indecent assault. Parties to the conflict should provide them with the care and assistance they need because of their age or for any other reason. Similarly, in Article 4, Section 3 of the second additional protocol, it was stated that children should be provided with the care and assistance also in the time of civil war. In particular, the right of children to education, including religious and moral education, was stressed, taking into account the wishes of their parents and, in the absence of parents, of persons caring for them. Another issue regulated by the international humanitarian law is the possibility of evacuating children in times of war. According to Article 17 and 23 of the 4 Geneva Conventions, the parties to the conflict should strive to conclude local agreements on the evacuation of the wounded, the sick, the disabled, the elderly, children and pregnant women from the beside of surrendered zone, as well as on the admission of clergy of all denominations, as well as sanitary staff and equipment, and to allow free passage of all consignments containing essential food, clothing, and reinforcement instead for children under 15 years of age and pregnant women. In recent years, much research and development has been devoted to the civilian protection during armed conflicts. However, none of the discussed regulation directly address the issue of children with disabilities. As the analysis shows, humanitarian law has a huge gap in the special protection of people with disabilities, including children, during armed conflicts. This gap is at least partially filled by the Article 11 of the Convention on the Rights of Persons with Disabilities. This provision is the bridge between the traditional field of civilian protection in international humanitarian law and the new field of the human rights of persons with disabilities. It calls for traditional civilian protection regime to be broadened to encompass people with disabilities and specially address their protection needs. Ensuring the adequate protection of people with disabilities in humanitarian crisis requires a well-integrated and implemented policy approach to drive field-based solutions. The conventions acknowledge that persons with disability compel specific attention in international humanitarian law paves the way for a representation of the ways in which men, women, and children with disabilities experience armed conflicts. NATO and its individual member states have an important role to play in carrying forward this important agenda. To sum up, as a de lege ferenda conclusion, it is necessary to indicate the comprehensive regulation of the issue related to the special protection of persons with disabilities, including children, on the basis of humanitarian law. In particular, should be regulated issues related to access to medical service, rehabilitation, psychological care, assistance of a special assistance, or the organization of specially designated places away from military purposes. Thank you very much.
Thank you very much for your interesting presentation and moving photos. So now I'm giving voice to myself. One moment. Okay. Yes, and I have problem because I have presentation and I can't.
Taki przycisk tam jest, Katarzyno, obok mikrofonu, dwa monitory. To musisz chyba na ten nacisnąć.
Tak, ale u mnie nie działa właśnie.
Na samym dole. Kamerka, mikrofon i dwa monitory. I tam masz udostępnij ekran.
Tak, ale nie mam wyboru okna. I can choose my presentation.
Zbigniew, my friend, could you help her?
Yes. Oh, maybe here. Moment. No, I can see my presentation in this view. Once again. Oh, maybe this time. Yes, but still I see other windows and not PowerPoint. Oh, maybe here. Okay.
Katarzyno, jest widoczna prezentacja
Yes,
twoja.
it's okay. Can you see?
Yes.
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 Yes, of course, everything is okay.
Okay, thank you. So my lecture is a bit historical, but I have photos also. So maybe it will be interesting for you. This is part one of our considerations on the standards of international and national law in the protection of children with disabilities. And each of us deals with slightly different issues. Mine concerns accessibility as a principle of international law. And in this part, taking the opportunity that it's introductory part, I would like to present the origins of accessibility in international law and show two ways how the contemporary model of human rights has increased. And because accessibility refers to all specific rights, I believe its analysis can be fruitful in our research on them. Okay, so when we look at accessibility, we can perceive it as an intellectual concept, as a technical, sociological category, and of course, as a normative category. And it depends on our perspective. But in this photo, you can see, of course, President George Bush in the celebration of signing ADA. ADA is American Disability Act of 1990, and it's very, oh no, you can see second, yes, but I would like to show you third photos. So in this photo you can see President George Bush in celebration of signing American Accessibility Act. And this act broadly refers to the accessibility. Someone even counted that almost 40 countries modeled themselves on the ADA. ADA is abbreviation of this act. So of course, first of all, we are, lawyers, interested in a normative category when we think about accessibility. And usually we analyze accessibility as a part of legal system. We seek answer to the question like, what is the nature of the legal norms of accessibility? Does this category create new rights? We verify whether the legal norms are respected or effective. But we can consider other perception like technical category, and the roots of a technical concept date back to the time when standards for the design of buildings, public spaces for the elderly, and workplaces accessible to persons with disabilities were sought. And in the early 60s, first technical specification for the accessibility of buildings and other public facilities appeared in the United States. And this was, of course, a consequence of demographic changes, the progress of medical technology, and the extension of life. Technical norms allow to measure accessibility in terms of its appropriateness, connectivity, diversity, intensity, means of accessing them, and of course, and affordability. So in the photos, we have two modern buildings, but one on the right is the example of universal design standards. But on the left, we have library, which was literally heralded as an architectural triumph when it opened in 2019. But we can see how is it inaccessible to people who have problem with mobility. It's not only to people who have problem in moving, like people in wheelchair, but generally to people who have problem with any mobility. And next perspective, sociological perspective, try to imagine Professor Stephen Hawking without new technologies. He was diagnosed in college, so his whole scientific career, he was a person with disability, and he's an excellent example how the paradigm of disability was changing. And in the 60s, organizations, NGOs of persons with disabilities started to formulate a new concept of disability, which indicated the close connection between the limitation experienced by individuals and the environment, also the attitude to persons with disabilities. Now in the CRPD, in the convention, disability is described exactly as an evolving concept, what means that disability results from mentioned interaction. And here we add a bit opposite story. We know Oscar Pistorius. He's best known for his successful sport career, and he's a person with congenital disease, so he born as disabled child, and he raced with able-bodied athletes. He was the first to compete with them, and maybe you remember after Olympics in London, he was accused that with his prosthetic legs he had an advantage over the other runners. Yes, so we can ask if the accessibility is only opportunity or maybe it's advantage over others. But generally his story, we know that it's his story without happy end, and he stayed in prison after, I think, killing his girl. An intellectual category, we can perceive accessibility as the concept of whether a product or service can be used by all potential users in many different multiple contexts. Accessibility refers to the ability of individuals to participate in all human life activities, to the provisions of services and infrastructure, employment, education, and housing opportunities, and also activity in social or cultural life. Accessibility is also a research area of many scientific disciplines: urban planning, spatial planning, architecture, as well as sociology, public policy, geography, even crisis management and ageism. And it's widely believed that social legal norms, public policy, shape perceptions to disability. They can limit or they can shape and support the rights of persons with disabilities. So we know that accessibility is a key to being able to fully function in the society, but we tried for decades, for decades existing of human rights, to match people to places, not the other way around. So why did the concept of accessibility appear so late? Why is the history of disability rights not an accessibility story? In the first half of the 20th century, the ILO adopted a number of conventions and resolutions addressing both to rehabilitation and the prevention of future disability. Generally, medical rehabilitation was a public policy aimed at people, including treatment and adaptation of these people to the environment. And here only one example in the photo related to the education of blind people, because we commonly educated them as a massage therapists, regardless of their aspirations, passions, and interests. So I'm asking again, how did it happen and why did we care of accessibility from the beginning? And to answer these questions, we need to take a step or even two back. So we are here. This photo evokes the historical moment for the development of the rights of people with disabilities, because it was crucial to the direction which the rights went, which the rights developed. And I should already emphasize that, of course, mainly for European countries, but generally the rights of persons with disabilities have specific historical background for me. They were not the result of social gain, like, for example, a struggle for the trade union, for decent salary, and for the right to work on an equal basis with others. But this was the result of the public policy initiated by the states. First were Germany, Austria, Poland, Italy, and France, and they worried about workforce. Then they obliged employers to employ a certain number of war veterans. And when an even bigger problem arose after World War II, including massive civilian casualties, this solution was recommended in ILO recommendation to extend to all people with disabilities. So in Europe, we were influenced by the experience of war. More and more affected as civilians by the war. They had legislation dedicated to veterans in the United States, but it wasn't the ignition moment for development of the civil rights and concept of accessibility. And you can see Rosa Parks. We know her, and we can place her in the history because she was an icon. She was the mother of the civil rights movement, of course, against racial discrimination. And they, the Black community, started to rebel after killing a child. In the second picture, you have a mother with her child, with her daughter, after a trial in the Supreme Court. And the parents were fought against segregation in the public education, and they won. And it was an example for other vulnerable groups, also for disability movement. So here we have other cases of disabled child. Parents of disabled child followed the same path. It's the same like parents of Black children who are segregated the same way in public schools. And here are two examples of lawsuits. The Pennsylvania Association for Retarded Citizens against Commonwealth of Pennsylvania and Mills against Board of Education in Columbia. These cases finally led to the passage of the Education for All Handicapped Children Act in 1975. Of course, disability movement was wider, embracing adult and family members of adult Vietnam veterans, all of them advocating for the changes in law. And the last act, the Rehabilitation Act of 1973, was the first to provide equal access for persons with disabilities by removing architectural, employment, and transportation barriers. Of course, at that time in public spaces. So, when we are keeping in mind aftermath of World War II in Europe and civil rights movement in the United States, become obvious two ways of regulations the rights of persons with disabilities. We understand why legal regulations develop differently in Europe and United States. On one side, we have quota model or social model with special treatment, segregated employment, but also with wage subsidies and extensive social security. On the other, anti-discriminatory model, sometimes called civil model, with equal rights, civil movement, and first technical standards for public facilities, but without too many benefits. So first photo, it's document with the first concept of quota model from 1923, as I mentioned. And second is a group of activists with Judith Hoyman in the foreground. They were protesting in favor of implementing regulations to the Rehabilitation Act. This protest was called the 504 sit-in because they occupied federal buildings to push the introduce of delayed regulations regarding this section. This section 504 was enacted, but was unenforceable. So prior to the enactment of ADA, the Rehabilitation Act was the most important legislation in the United States for persons with disabilities. So when we think about legal norms of accessibility, they are related definitely to the civic model, human rights movement, disability rights movement, to striving for equal treatment and equal opportunities. And we commonly view the CRPD, I mean Convention on the Rights of Persons with Disabilities, as the normative source of accessibility. But the question is whether the CRPD is a primary source. But first, a little about standard rules, because there were the intellectual basis for its adoption, of convention, and they were earlier. They were in 1993, as can you see. So it wasn't legally binding instrument, and I don't want to discuss entire rule number 5, but just take a look how much a concept was it that time. Rule 5 suggested new obligations for states, described access to environment, information, and communication, and mentioned even about new computerized information and services. It was 1993, yes. And the drafters of CRPD were suggested and influenced by these rules. And it was a special year for human rights at all, because the World Conference on Human Rights took place in Vienna in the same year. A main outcome was the Vienna Declaration and Program of Action. It has been said, very important thesis, that all human rights are universal, indivisible, interdependent, and interrelated. So it was a very strong, innovative declaration and big shift in the perception of all human rights. No, I can't change. Okay, and here we have Article 9 of the CRPD. You can also take a look at this article and notice that convention requires to implement minimum standards, embraces many areas of accessibility, access to space, to transport, communication and information, new technologies, to facilities, goods and services, and also it is addressed to private entities. But there's a problem with perception of convention as a primary source of legal accepted norms, because the dominant view is that this convention is only implementing instrument in international law. So it doesn't create new rights, especially after the adoption of the convention was considered as an act which only expresses all existing human rights in appropriate manner for the needs of persons with disabilities, describes these rights in the context of disability, and contains tools for the realization of the previous existing rights. And for this purpose, in general comment, the committee cites regulations concerning access to selected areas, Covenant on Civil and Political Rights, and the Convention on the Elimination of All Forms of Racial Discriminations. In the view of the committee, international law set up the right to access already years ago in previous treaty law. So we can reach conclusion. There is a serious problem. What exactly are the sources of accepted legal norms? I think those earlier treaties referred only to access to a specific solution, very detailed solution, and they didn't make a new legal institution. The concept has matured among NGOs in the environment and various fields of knowledge, and the opening up to a new concept in the international law was the Vienna Conference, with a new paradigm of human rights and the standard rules with the thoughtful, mature concept of acceptability, and of course then CRPD as legally binding instrument. So completely at the end of conclusions, why new institutions were refused in the convention? Why didn't the committee negate the new rights in the convention? I think we know the reasons. It's difficult to admit that existing human rights were insufficient, not only in the sense like we call sometimes law, toothless law, or act without implementing measures, but the legal loophole was bigger. There were no adequate categories of human rights, which are definitely needed to the protection against of exclusion of people with disabilities. And second reason, there is fear, and fear of human rights inflation. It's thought that an increasing number of human rights can lead to the confusion about values and erode the regards for those rights, which we consider more fundamental. So this is the end. Thank you for your attention. Thank you very much. Okay, now we can start discussion. I know that it's time up, but maybe you have some remarks or some questions.
I think for the first time it is maybe enough, because it's starting to get dark and it's maybe time to get rest.
Okay, so I know this was our first meeting on this topic, and I want to thank you very much for the excellent, inspiring lectures and presentations you gave. So I wish to express my gratitude to all speakers, and thank you so much. And so see you again on the next seminar. Yes.
May I
yes,
have just
Marta?
one question
Okay.
regarding it's just a practical, technical thing, that what should be on our report that is sent to you, the date? It's starting with 25 or 15th of April.
But are you asking about?
The report of performance that is sent to you. So when is the starting
I think we
date?
have information in our agreements I don't remember now exactly.
Yeah, but there was a question about. Okay, anyway, I will ask again.
But you mean about money reports or
No. I
report
mean,
connected with monograph?
I already sent you a question, and you told that maybe you will ask.
The term. Okay, the
Yes,
term.
the
No, I don't have answer. I
Okay.
have to ask again. Yes, I
Okay,
remember.
thank you. That's all. Thank you.
So thank you. See you then.
See you then. Bye bye.
Thank you so much. Bye.
Thank you very much. Goodbye.
Thank you.
Bye.
Bye.
Bye.